You either have it or you don't. And if you don't have it, you down your tools. So we want to persuade the court that on this matter you are raising, we must down our tools. Downing tools is not taking away tools. It's not a sign of derogation, but it's just downing the tools. And, Your Honor, the commentary by Justice Odunga in this matter, in paragraph 37, 38, 39, 40, and this is a matter in relation to a tribunal, and he was saying that even if the tribunal had to apply the Constitution, he can only apply that Constitution or interpret that Constitution in relation to a matter in which the tribunal had jurisdiction. So we are saying that this is a matter in which you do not have jurisdiction. Now, the other issue that we are raising, which I put out in summary, is that Chapter 6 of the Constitution is a very important creation an innovation in our Constitution, which talks to matters integrity, leadership and integrity. Now, under that chapter, Parliament is directed in Article 79 to enact legislation to establish an independent ethics and anti-corruption commission, which shall have the status and powers of a commission under Chapter 15. My Lord, if you look at Article 249 of the Constitution, particularly 249(2), the commissions and the holders of independent offices are only subject to this Constitution and the law, are independent and not subject to direction or control by any person or authority. There is a constitutional requirement that the Commission shall not be directed or controlled. My Lord, if you look at Article 157 of the Constitution, which relates to the powers of the Director of Public Prosecution, it says in Article 4, Subarticle 4, the Director of Public Prosecution shall have power to direct the Inspector General of the National Police Service to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with any such direction. So under our constitutional arrangement, the only person or office that the Director of Public Prosecution can direct or give orders in respect of investigations of criminal conduct is the Inspector General. Now, unfortunately, for the Director of Public Prosecution, if you look at the charges in the charge sheet, they relate to offenses provided for under the Ethics and the Anti-Corruption Act. Yes, and the Honor, just to address this point, the statute which talks to the creation of the commission by an act of Parliament enacted in compliance with Article 79 of the Constitution, Section 28, the Ethics and Anti-Corruption Commission Act, says, and it speaks of independence of the Commission, except as provided in the Constitution and in this Act, the Commission shall, in the performance of its function, not be subject to the direction or control of any person or authority. So the case that we want to make, which is about abuse of process and lack of fair hearing, is that the Director of Public Prosecutions capriciously, malafides, and with ill motive has taken these matters to the Director of Criminal Investigations, because he knows that that's where he can give directives, as opposed to the Commission. And the proposition that we want to advance to your honor is that insofar as the chapter dealing with leadership and integrity in the Constitution and the enactment of Ethics and Anti-Corruption Commission is for purposes of dealing with matters that relate to corruption and the economic crimes, which we all agree must be dealt with. But because they relate to public officers and state officers, in order to ensure that not every accusation that is brought on board is rushed to court, offenses that relate to the Ethics and Anti-Corruption Commission are to be investigated by that commission. And they do that without direction from anybody. The function of the commission in the Act, the Ethics and Anti-Corruption Commission, is found in Section 11, 1D. In addition to the functions of the Commission under Article 252 and Chapter 6 of the Constitution, the Commission shall investigate and recommend to the Director of Public Prosecution of any acts of corruption or violation of codes of ethics. So the Director of Prosecution was telling the Commission, don't waste my time. I'm going to deal with this my way. But the law does not allow him to do it his way, because the Ethics and Anti-Corruption Commission Act has a full regime, code of law that relates to investigations, particularly to the offenses which are created under that act. Section 45, 46, and so on, are created under the Anti-Corruption and Economic Crimes Act. What is important in that? It is important, first of all, you would notice that the commissions are given the power of the police. They can investigate, they can arrest. They have many other alternatives, mechanisms, asset seizure, requirements for explanation of assets. And because this has got to do with the integrity of public officers, Section 33 requires that no person, except with the leave of the director or with other lawful excuse, disclose the details of an investigation under this act, including the identity of anyone being investigated. Now, everybody in Kenya knew that the Deputy Chief Justice was being investigated before even the director talked about it. You can see headlines. She has fallen. How is this information getting out there before even the director of public prosecution has said anything about it? This is the protection that was put in this act to ensure that whereas we require our public officers to be guided by the dictates of Chapter 6, in doing so, they should not be bashed around. Which is what is happening in this matter. With respect. And at the end of the investigation, what is the commission required to do? Section 35. Following an investigation, the commission shall report to the director of the public prosecution on the results of the investigation. 2, the commission's report shall include any recommendation the commission may have that a person be prosecuted for corruption or economic crime. Now, this is an economic crime. Corruption. You can see the sections referred to basically falling under that act. And the work of the commission is subject to quarterly reports which have to be given to Parliament, to the President, for examination so that they are accountable in some form or shape. So we are saying under the circumstances in which the Director of Public Prosecution has cherry-picked which institution to use for the purposes of this case, we are saying it is not for nothing, it's for a malicious purpose, it's malafidis, and it's to deny the accused persons an opportunity to confront even the allegations that have been made. Your Honor, for example, in count 2, we have an answer. To show that whereas the accused number 1, through the lawyer, gave a professional undertaking to pay the loan and replace a title after a discharge. The lawyer gives 2 undertakings: pay the money, give an alternative title. The bank does not wait for that. As soon as you paid 65 million, he says, have your title. I know Malani friends, with respect, would say that's a matter of evidence, and I'm saying it purposely because that is the evidence we want to place before the High Court to show that these charges are a sham. And Your Honor, while at it, I want to share, and I'm not saying this as an authority, as it were, but one of the most famous judges in America in the Supreme Court was a judge by the name Justice Frankfurter. He served in the Supreme Court.
Justice?
Frankfurter. His name is spelled Frank and then F-U-R-T-E-R. Him and colleagues in the Supreme Court were involved at a time when the United States was dealing with a war situation, the Second World War and the war in Korea. And the executive felt, the President Truman felt that in a war situation, the executive can do anything in defense of the country. They even took possession of steel mills. They said, we want to produce weapons. And these companies are not doing it fast enough. We are taking over these steel mills. So the words of Frankfurter that I want to share with the court, he says that dangerous power which is accumulated by a government or a state organ does not come in one day in a single stroke. It comes slowly. From a force that he calls regenerative. And is a force of unchecked disregard of restrictions. The law places some restrictions, some which are very small, but slowly. And we have that experience in 1980s. Slowly you come to a court, even to get bail. You're told bail is not a right if there's a question of state security. You know, there was that kind of dubious, postulation at that time. And it was coming slowly, and judges who tried to check it, some of them suffered. There's a judge called Schofield. And you all know what I'm saying is that what the DPP is doing is a disregard of a law that is useful to him, because ultimately he is the one to carry out the prosecution. And he goes to the wrong institution. And we're saying that is for an extraneous purpose which has nothing to do with the objectives of the criminal justice system. For example, Your Honor, yesterday, I was very happy yesterday when you said, why do you bring an accused person at 5 o'clock? Your Honor, in 1980 it started like that, and everybody was being brought to court at 9 o'clock. The working hours were there those days. Official government hours were there. But because the state slowly had been allowed to take people to court at 6 o'clock, then they come at 7, they come at 10 p.m. It became the practice. Yesterday, I went home smiling because you could see and read the mischief. And there was no explanation for that mischief. Even that fact alone yesterday for bringing the Deputy Chief Justice to court at 5 o'clock, beyond 5 o'clock, is an exemplification of the malice. Your Honor, we are therefore saying in conclusion, we have raised issues about these pleadings, about these proceedings in relation to Article 50, Article 27, Article 28.
So in relation to articles number?
27, which is the equal protection of the law, protection and benefit of the law, Section 50, more particularly Article 50, and more particularly Article 2. And in Article 50, we are dealing with more than 5 violations and infractions. And then the right to dignity, Article 28. Those are not matters in which this court has jurisdiction. And the other, I want the court to take judicial notice to what has just happened today. Cases that have just dealt with. They are not even hearing dates. People they are brought here, they are not hearing dates. So why should we be in a hurry when there is a serious constitutional question of a matter of a violation? Is the date more important? Or is the trial more important than respecting rights? And to ensure that the powers granted or donated to the Director of Public Prosecutions are not used in abuse of Article 157, sub-Article 11, that requires of the Director of Prosecution to ensure that the